far off from that. But that can be an understatement. But to have an understanding, the right perspective, I think, true to his name of Rajagopal, he's Raja of knowledge, and whatever interaction we have had off the screen and on the screen, it has always been that you feel that you should know what he has known. Therefore, when we took the session on today's chapter 2, sources, recruitment, mode, and employment, I thought that at the end of the session, we would like to understand what are the sources from which one can gain knowledge. What are the rules in life where we can gain forward ourselves? What can be mode from which we can gain different knowledge, not only on law, but beyond law, which is synonymous to the YouTube channel of Beyond Law CLC. And then, do we get any equal opportunity into the profession, or we have to march ourselves and create our own stamp within the field? These are the few 4 or 5 questions which will we take at the end of the session. And on a weekend, to have knowledge from Mr. P.S. Rajagopal, who is taking this entire endeavor to simplifying the law. There couldn't be a better way to understand that too on a Friday. Fridays, they say, even on the market, they say that they give the best price on the Friday because people have more money and they can spend more. But here we are detaining the people, don't spend more, but have knowledge from a person who can actually share the knowledge. Over to you, sir.
Thank you, Chris. I am only trying to improve the practice of service law so that the working class, I would like to classify all employees as working class. According to me, the definition in labor law is too restricted. Every wage earner or every salary earner is a worker. As Lordship Justice Krishna here put it once in a public speech in Bangalore, every one of us are workers. We are law workers. Then there may be engineering workers. There may be medical workers. All of us are workers. Therefore, the endeavor of service law is to make the working conditions and workers' life better. Last time I was speaking on sources of law, sources of service law. Today we will be speaking about sources of recruitment, because recruitment is the first step before the employer-employee relation is made. There was a time when source of recruitment was restricted to father-in-law's acquaintances, or his family members, or your uncle's children. In fact, one of the chief ministers went on to say, do you expect me to appoint the son-in-law of Bansilal when my son-in-law is available? But when we are talking about employment in government and governmental sector, luckily for us, the system is more orderly, and the freedom which either government or state sector enjoys in the matter of recruitment is limited by constitution, is limited by rules, and is limited by constitutional values. Now, what are the sources from which we can enlist people to serve the state or its instrumentalities? Before we go to these sources, first, at the first step, we should understand that recruitment is only the first step, and it is not synonymous with the word appointment. It is famously said, while every appointment is preceded by a recruitment, every recruitment need not be followed by an appointment. Or to put it differently, While appointment follows recruitment, recruitment does not always culminate in appointment because the two are distinct. Recruitment simply means enlistment. Enlistment of what? Enlistment of a candidate who is found eligible to be appointed. Here again, eligibility should not be confused as a single concept. There is eligibility to apply and then eligibility to be appointed. The eligibility to apply will allow you to enter the recruitment process. At the end of the recruitment, if you come out successful, you will be declared as eligible to be appointed. Now let us see what is the first precondition for recruitment. Recruitment can only be to a post. If there is no post, there can be no recruitment. Post need not always be a permanent post. Even if it is a temporary post, there can be recruitment and there has to be recruitment. That is because Constitution says our constitutional values dictate that even a temporary appointment cannot be made without complying with constitutional requirements. It is said in P.K. Rajamma that there can be a temporary employee against a permanent post, and there can be a permanent employee against a temporary post. Therefore, nature of appointment and duration of the post are two independent concepts. But suffice to understand that there must be a post before a recruitment could be initiated. If there is no post, there can be no recruitment. The post means an appointment, a job, office, or employment. There must be a position which is vacant, which we call as vacant post, before the recruitment process is initiated. Now, what are the modes? In a huge organization or even in a smaller organization, suppose you have to choose people to occupy, let me say, post of general manager or deputy general manager or manager. First source that would be available to the employer would be internal. That internal source is the already existing staff. Then there is an external source. What is an external source? The external source is open market. Don't take objection to the word market because open market, why I am saying using that phrase is unemployed constitute a huge base of qualified human resources from which we can draw. Therefore, I use the word market in a larger sense, where goods, services, and personnel of different caliber, different qualifications, different acumen are available. And you draw on those resources by way of direct recruitment. Therefore, broadly, there are two sources. One is internal, another is external. Of course, these days we also have campus recruitment. But campus recruitment is unknown to the constitutional values because it is not that you give opportunity to students of one college and ignore students of other colleges. Therefore, if we have to go by the concept of equality before law as enunciated by Article 14 and equal opportunity in public employment as propounded in Article 16(1). The campus recruitment is no insofar as public employment is concerned. Within these two sources, one is external and another internal, there are further classifications. When an external candidate who is not in the organization, he tries to enter your organization by applying for direct recruitment. And the internal candidate normally moves up by way of promotion. Can it be said that internal candidates are excluded from competing in direct recruitment? There cannot be an exclusion of any qualified candidate, even if he is already in your service, from the direct recruitment. At best, you can say that for a candidate who is already in service, if he has to apply, he may have to seek permission of the employer, or he will have to route his application through proper channel. Beyond that, his right to compete in direct recruitment cannot be denied altogether. Of course, there can be some restrictions, like which are reasonable restrictions. In one case pertaining to stenographers in the High Court, I had a very strange experience. Some stenographers of the High Court, they wanted to apply for direct recruitment of stenographers post in the Secretariat Service of the state. Since they were already employed in the High Court, their applications required to be routed through the High Court registry. When they made an application, forwarding of that application was denied on the ground that there is shortage of stenographers in the High Court. And that was upheld by the division bench of our High Court, and SLP there against was dismissed. And the learned judges constituting the bench, they said, Rajagopal, even in Supreme Court, we are facing a shortage of stenographers. Therefore, denial of opportunity to them is proper. But as a constitutional principle, the persons who are already in employment, if they want to compete for a higher post within the organization through direct recruitment, that opportunity cannot be denied. Then again, there is another line of progress by way of direct recruitment for internal employees. In some of the organizations, at least you will find, in some of the departments of the government also you will find, that a certain percentage of direct recruitment quota is reserved for internal candidates. And it is called as direct recruitment quota for in-service candidates. Therefore, in direct recruitment, though stricto sensu, we understand it as external source. Internal resources also can participate. Then there is from the external resources, it is not that always direct recruitment amount can take place. There could be deputation. Deputation is again of two types. So under the same employer, just like a transfer, a person can be deputed. That type of deputation is not preceded by any selection. Therefore, there the question of recruitment is not addressed. But there are posts, there are cadres, particularly at the higher levels of the organization, where deputation, appointment by deputation for a fixed tenure is the most preferred mode. These days, if you see any advertisement issued by the central government for the higher positions, like Director of Power Research Institute or Director of a educational institution owned by central government, the mode of recruitment would be direct recruitment, which can be from open market or on deputation. There it follows the candidate seeking appointment by deputation has to undergo the same process of selection as an open market candidate would undergo. But only difference is, if it is from open market, it will be till superannuation or it will be for a longer tenure. But if it is appointment by deputation, then it will be for a fixed tenure. Recently, you must have seen a judgment in the law reports, that is Union of India versus N. Murugation. That was the case of appointment to the post of Director, Central Power Research Institution, Bangalore, where he was already an employee in some institution, and he thought when he applied that he is applying through direct recruitment, therefore in the new institution where he joins, he can work till retirement. But a condition was imposed in the order of appointment that it is a tenure appointment of 5 years. And at the end of 5 years, he has to go back to his parent organization. Such a condition was upheld by the Supreme Court in a Murugation's case. Now, the sources should not be therefore confused with modes. There can be an internal source for direct recruitment. There can be an external source for deputation. And the external candidates, they can be also laterally inducted at higher echelons of an institution. Now the modes are different and sources are different. Though in some of the judgments of the Supreme Court, you would see the mode and the source being used as interchangeable. There are any number of judgments which of the Supreme Court which say sources of recruitment are direct recruitment, promotion, deputation, and transfer. And transfer within the organization is a very peculiar source of recruitment. Generally, transfer is a lateral move. A junior engineer will move to another post in the cadre of junior engineer. Assistant engineer will move to another post in the cadre of assistant engineer. But a very strange rule or peculiar rule is found in almost all the state service rules. But particularly in Karnataka also it is there. That is, a diploma holder enters service as junior engineer. On his acquiring BE degree, he moves to the higher post of assistant engineer, and it is treated as entry by direct. Therefore, we should not confuse between source and mode. They are quite different. Then we go to a very difficult question, that is, normally we say that rules are supreme. That is, when there is a rule or a regulation governing service conditions, governing conditions of recruitment. They have to be followed. A question arose before the Supreme Court, first regarding government service. Suppose a department is established, say for example, now it has become a fashion all over the country to have a department called as skill development department. Of course, government itself does not know even today whether it is a program or whether it is a permanent department. When a department or when a service is created for the first time, the question is whether the employer is not authorized to make any appointment unless the rules are framed. Or take the case of a road transport corporation. All these state road transport corporations were established under the provisions of Road Transport Corporation Act. The question in the Supreme Court, before Supreme Court in B.N. Nagarajan was, yes, state service is formed, but no recruitment rule is made. Whether the government is incompetent to make recruitment until a rule is framed under Article 309. Now, Article 309 of the Constitution envisages determination of recruitment rule as also conditions of service by way of a rule made either by the legislature or by the executive in the name of the governor under proviso to Article 309. The issue raised was, look, here is the government. Article 309 compels it to make a rule, and recruitment is being made without making a rule. The answer given by the Supreme Court is very, very pragmatic, and it serves the real issue that it takes cognizance of the ground reality that after formation of a service, after creation of a service, there may be a time lag between making of the rule and need to fill up a post. Need to fill up a post will be immediate, whereas making of the rule requires some time. Therefore, Supreme Court answered the question, saying that if there is no rule made under Article 309, executive power under Article 162 is available to the state. Therefore, in the absence of a rule, the state government can make an executive order laying down the qualifications for the post, scale of pay, number of posts, method of recruitment, and in terms of that executive order, the process of recruitment can go on and it can culminate in appointment also. But this also, the Supreme Court also entered a case. If there is no rule, you can constitute a service and make recruitment to the service by executive order. At the same time, if there is a rule, executive order cannot be. Therefore, the Constitution gives enormous flexibility to meet the real urgent needs of the situation. But at the same time, it also says, whether it do it by executive order or by a rule under Article 309, the rule, the process and the procedure must satisfy the requirements of Article 14, Article 15, Article 16, and then the special needs of the depressed classes or backward classes as envisaged by the Article 335 of the 235 of the Constitution, and therefore all these will have to be satisfied by any executive order. In respect of the service under statutory corporations. Take, for example, the 45 of the Road Transport Corporations Act envisages determination of recruitment rules, service conditions, modes of recruitment, everything by a regulation made under Section 45. Likewise, Banking Companies Acquisition and Transfer of Undertakings Act envisages making of a regulations under Section 19 of the Banking Companies Acquisition and Transfer of Undertakings Act. The question before the Supreme Court was that the regulations insist that the service conditions and rules of recruitment are determined by regulations. Whether in the absence of regulations, the corporation cannot make any recruitment at all. Division Bench of Karnataka High Court had held that no such recruitment can be made or no such recruitment is possible unless regulations are made. Supreme Court said that when a corporation is formed, it has to function. Therefore, it becomes necessary to make appointments, and it is inherent power of the management, because when management is vested in a board, management includes making of appointments and see that the corporation functions. The corporation is functioning is not stifled. Therefore, in the famous judgment, that is in Gundopant Gundachar, the Supreme Court said that State Road Transport Corporation can make recruitment and appointment even in the absence of a regulation. Therefore, to sum up on this aspect, while rule or regulation is not undesirable, and it is very, very desirable and necessary to be made, in the absence of regulation or rule, executive order in the respect of the governments or administrative instructions in respect of other bodies which are treated as state under Article 12, it can be made. Now we have been seeing in various organizations, there is always a clamor for promotions, and it is desirable also, because unless an employee has something to look forward to, productivity will be stifled. There would not be any incentive to work except receiving salary, that too on a time scale. In the matter of promotion also, because let us remember one thing, while inducting employees into the organization that is newly formed or a department that is newly created, whether it may be, while it may be emergent, in respect of consideration of cases for promotion, there would be sufficient time available to the government or the employer to make a rule before embarking on promotions. The question often arises, let us take, there is a rule that 50% of the posts in the cadre of so-and-so shall be filled by a promotion. There is no process of promotion laid down in the rule. The inadequacy in the rule is noticed. But when that inadequacy is noticed, is it compulsory for the employer to wait till that inadequacy is made up in the rule, or whether gaps or inadequacies in the rule can be filled by administrative instructions. This question was answered by the Supreme Court in Santaram Sharma, where the Supreme Court said, even in the absence of the rule, there can be promotion subject to two conditions. First condition is that every eligible employee must be considered for promotion. What is meant by every eligible employee? It only means that eligibility condition must be first determined either by the rule or in the absence of the rule by administrative instruction. And the absence of these details was treated by the Supreme Court as a gap in the rule. And it made the statement that while executive instructions can fill gaps in the rules and supplement the rule, it cannot supplant it. Therefore, whether it is direct recruitment, whether it is promotion, the employer is always entitled to make the recruitments if there are rules in accordance with the rule. If there are no rules, in accordance with administrative instruction, which satisfy the constitutional norms. The next issue that would arise in the matter of the recruitment is, as I was telling in the beginning, there are various modes by which recruitment can be made. Promotion is there, transfer is there, deputation is there, and contract appointment is there, temporary appointment is there, permanent appointment is there. All these options are available. Now, if the rules stipulate that this post shall be filled up by promotion, these many posts shall be filled up by deputation, that rule has to be followed. Let us take a case where rule does not stipulate what should be the method of recruitment or mode of recruitment. Again, this is also a possibility and a reality in number of cases. Say, in most of the public sector organizations, qualifications are laid down for the post of director or head of the department. But method of recruitment is not stipulated. There may be cases where it stipulates it shall be filled by promotion, failing which by direct recruitment, failing which by deputation. There, the rule would have laid down the steps to be taken for filling up the post. First, you should try the route of promotion. When that is not available, then you can go to the route of direct recruitment. If that is also not possible, or for some, if it all that is also not possible, then deputation and all that. If there is no rule as to the manner or mode by which the post is to be filled up, and if there is a post, it is absolute discretion of the employer to choose whichever mode the employer desires. In Nilanshu Bhushan Basu, this question was answered by the Supreme Court. When there is no mode of recruitment stipulated by the recruitment rule, it is the absolute discretion of the employer to choose the mode which he feels will be most appropriate for the said post and in the said circumstances. It also made a statement which is very instructive. It said, sometimes the posts of this nature may be well advised to be filled by deputation. What it meant was, if you permanently promote a person to that post, you are stuck with his inefficiency or efficiency or lack of integrity or presence of integrity for the rest of his life. Whereas if you fill that post by deputation, you can have the opportunity of repatriating him to the parent body at the end of the tenure of deputation. Now, when I am saying equality of opportunity, that is Article 14 and Article 16. And when I say that every eligible employee has to be given, every eligible candidate has to be given opportunity, that is on the anvil of equality of opportunity in the matter of public employment. There was a time when the employer would write to the employment exchange to sponsor the names. Employment exchange would have maintained the list of persons holding postgraduate degree, persons who are holding a graduate degree in medicine, like that, the list of persons holding a degree in engineering, and the employment exchange to sponsor the candidates according to senior. That list, get that list of sponsored candidates, then the employer would select from amongst those candidates sponsored, whoever is the best according to him, and select him for the post for appointment. This was going on for quite a number of years or quite a number of decades also. I can tell from my own personal example, in the year 1971, when I did my post-graduation, I did not make any application to be appointed in any government college. I was just required to register in the concerned employment exchange. Then according to the seniority of that candidate, whenever intent comes from the employer, the employment exchange will sponsor them. On that basis, the interviews or whatever selection process they are invited, it goes on. This method of getting candidates from employment exchange only was reversed or was held illegal in N. Rajagopal's case by the Supreme. Subsequently, it made very clear in a subsequent case of that is KBN Vishweshwar Rao. Reference to KBN Vishweshwar Rao you will find in a number of judgments. KBN Vishweshwar Rao said that some people may not register themselves in the employment exchanges. For some people, because of their location, it might not have been possible to register in employment exchanges. If we are talking of equal opportunity in the matter of public employment, you will have to issue advertisement in widely circulated papers so that all eligible candidates will come to know of it and will have an opportunity to apply. Applying this Vishweshwar Rao, any number of appointments which had been made on the basis of earlier practices of inviting sponsored candidates from the employment exchange have been on. And that appears to be the true, that in tune with true concept of equal opportunity in public employment. Because why this recruitment process takes place? Why the employer cannot call anybody it wants and give him a chair? There are two reasons why that cannot be done. One is the constitutional requirement of equal opportunity. Even without the constitution, another requirement is that every enterprise should get the best candidate available for the job. And how do we get the best candidate? Best candidate is lay down the norm, issue an advertisement, then Every willing candidate will apply. From amongst them, you choose the best. Therefore, the Supreme Court very clearly said, explaining all these things, that merely considering candidates sponsored by employment exchange will be unconstitutional, and advertisement will have to be issued. Then there is another aspect of the recruitment, namely, the advertisement no doubt will have to be issued, and advertisement should contain what are the processes you are following, whether there will be interview, whether there will be written test, whether there will be written examination followed by interview. And sometime in the back, we had also for a very short while the concept of group discussion. And group discussion, even now it may be there in some places. I don't say it will not be there. It may be there. Then you should also stipulate what is the age limit. No minor can be appointed. Though my father joined service as a minor, then nobody beyond a particular age can be appointed. Then what are the educational qualifications for the post? Then what are the professional experiences for the post? All these things will have to be made known in the advertisement. And the date up to which the applications can be made should also be stipulated. And more importantly, the advertisement should also stipulate, when it fixes the qualifications, say age, it should also stipulate the reference date in relation to which your age eligibility or your educational qualification eligibility will be considered. Sometimes it may so happen that the advertisement does not contain the date of fulfillment of the qualifications. It may simply say holder of PhD degree in the concerned PhD in concerned subject with good academic record. That's all the stipulation. It doesn't say what is good academic record. It doesn't say PhD means what. PhD on what date. Then there were very ingenious professors, ingenious employers who would not hold the selection committee meeting until their candidate's thesis for PhD is approved. And they would very conveniently say, today the committee is meeting, on that day he fulfills the qualifications. Therefore, since on the date of selection he is qualified, we are selecting him. This was also answered with the Supreme Court in Rekha Chaturvedi's case. It said, fairness is that advertisement should disclose the date in relation to which or with reference to which eligibility is ascertained. There may be cases where the recruitment notification does not stipulate. In such case, the safest course is to take the last date for submission of the application as the date for which, in relation to which your eligibility is determined. It also said, and this is more important, date of selection is always uncertain. You can manipulate the date of selection in such a manner that you can select a person of your choice, not of the required merit. Therefore, there must be clarity. And in case of accidental omission to mention the date, it should be the last date of submission of the applications. Then there is another important aspect when we are talking about advertisement. Normally, the rule is that the employer is not to deviate from the terms advertised. That is what was said in Bedang Talukdar also by the Supreme Court. That when once you issue a recruitment notification, you have to complete the recruitment notification in accordance with the terms of notification. There is an exception. Exception, which is very interesting to know, was laid down because of an error committed in recruitment to the posts of district judges in state of Uttar Pradesh. The recruitment notification, while stating as to who are eligible for age relaxation, had included in the clause, included a class which was not entitled for age relaxation under the recruitment. The question before the Supreme Court was that. Now, under the advertisement, this class is entitled for age relaxation. Under the recruitment rule, they are not eligible for age relaxation. What should be done in such a situation? Supreme Court said that advertisement, error in advertisement does not confer any right on any candidate. If advertisement is at variance with the recruitment rule, it is the recruitment rule that would prevail and not the advertisement. At best, in such a case, that is not there in the judgment, but it is my addition. In such a case, at best, the candidate who has been wrongly made to apply and wrongly made to go for interview and had an expectation that he would be appointed, but this candidate is rejected, he may be entitled for some damages. But we know what would be the answer of the courts when we claim damages against the state government. Normally, the courts would say, what can be done? You are not eligible under the rule. Therefore, be happy that you got experience by writing written examination. There is the one more aspect is in respect of recruitment is that suppose a person is wrongly appointed, wrongly selected, and wrongly appointed, and it later on comes to, it later on transpires that he was not qualified and there was no vacant. What would happen? He has to vacate. His services can be terminated without any compliance with natural justice. The another important aspect in the recruitment jurisprudence is we talk of equality of opportunity and equality before law. I also said that there must be a vacant post before you can make recruitment. When you are initiating recruitment, can you initiate recruitment process only for the posts existing or also to the posts which you anticipate to arise in the immediate future or for future vacancies also? Another question that would arise in this connection is whether you can appoint or you can select more number of candidates than you have advertised. First part of the question is what vacancies you can notify, existing, anticipated, future. Second part of the question is how many people you can select. Can you select more than the numbers advertised? Now, when you advertise, you cannot take your next 10 years anticipated vacancies and advertise today because it will not be in your interest alone, as your employer's interest, since next year more meritorious candidates may be available in the market. Our education system itself might have improved. and more talented candidates also will be available. And from the point of view of the candidate seeking recruitment, seeking to participate in recruitment, if after 5 years a vacancy arises and a person is qualified for that, he cannot be told, no, sorry, beta, we have recruited for this post 5 years ago. Therefore, no vacancy. Therefore, the law on this point is the recruitment process can start only in respect of existing vacancies and anticipated vacancies, and not for future vacancies. Anticipated and future, they may look alike, but it is not difficult to make out the difference between the two. Anticipated means, like there is in the Trade Unions Act, there is one phrase, in contemplation of trade dispute. That is a decision or frame of mind. In the mind, it must have been settled that trade dispute has arisen, or it is likely to arise in the immediate future. That is contemplation. That is also the meaning of the word anticipation when it comes to recruitment. Future means, take the list of employees, mark their retirement dates, and future, after 5 years, one vacancy of person will arise in physics department. Therefore, I will advertise today. That is not permissible. And second is, any selection made in excess of the notified vacancies is bad in law. Therefore, these two conditions, that is, the vacancy must be immediately existing or anticipated, and then no selection for more number of vacancies than the advertised post. Of course, some rules stipulate that certain percentage of advertised vacancies you can say as additional list or reserve list, but that is also intended only to fill up the advertised posts and not additional posts, and additional posts more than what is advertised. Of course, today I have not been able to cover at least some of the aspects like classification, processes, weightages, consultations, etc., and including reservation. I intend taking a preservation in this separately, and then this classification, processes, weightages. These are all aspects of transparency in recruitment process and safeguards in recruitment process against abuse. I think that would form a separate chapter altogether. And now it is time to have questions from the participants instead of my continuing with my monologue or pravachan or whatever you call it. Because where are you?
Sir, sometimes you have to be in an oblivion. And sometimes you're so much mesmerized that you forget to unmute also. So this is by Khyati Sharma. What is the scope of judicial review insofar as challenge to eligibility conditions is concerned?
I can just tell one example. Unless the qualifications prescribed are outrageously illogical, it is for the employer to fix the qualifications. It is not for me to say let us say a post is advertised of Hindi teacher. What qualification, Hindi language or some other language also, in addition to Hindi, has to be prescribed? It is for the employer. Only case I can envisage where court can interfere with the qualifications is, suppose knowledge of Bharatanatyam or Kathakali is made compulsory for a Hindi teacher. Then it is outrageous. Only in such cases of outrageous defiance of logic, the courts can interfere. Otherwise, it is for the employer to determine what should be the eligibility conditions. Generally, the courts would apply a higher threshold limit for interfering with fixation of the qualifications by the employer. For example, only one thing, one constitution bench judgment I can say. In Trilokanath Kosa, diploma holders were made ineligible. Till then, diploma holders were treated as if were made eligible, were being eligible. Supreme Court said neither history nor the desire or aspiration of a person can make us interfere with the qualification stipulated. It is for the employer to stipulate. So there are any number of cases, even in respect of promotion. The classification based on educational qualifications was upheld. Classic case is Rupchand Adlaka, where Lordship Justice M.N. Venkatacharya sit was. He said, any classification will result in discrimination. And approach should be not to go in search of classification to the extent that equality is reduced to a rope of sand. After having said so, he upheld the classification of diploma holders and graduate engineers, and no relief was granted to the persons who questioned it. On qualifications, the role of the court is very, very limited.
The next question is the weightage in the oral interviews.
Oral interviews I have not touched it today because weightages, processes, consultations, classification, that forms a separate chapter altogether in the sense. I can just give a short
So we can say that they can watch the next webinar.
Yeah,
like
we can say watch the next episode.
Sir, like in the serial, they say abhi tak aur kal kya dekhenge.
Kal kya dekhenge. Because weightage for senior and for interview and the bias in the question of in the matter of interview, these are it is better I deal with that aspect separately. Therefore, I have noted which are the parts which are not covered in the recruitment. Classification based on qualification. Recruitment processes. What is the best method to test the suitability? And in testing the suitability, what is the weightage? And then, what is the role of consultation? And then safeguards against abuse of processes. This aspect of the recruitment, it will itself take about an hour, so it is better we keep it aside for the next session.
What are the grounds on which necklist can be challenged? They are so wider. It is just like asking what the rules can be changed midway.
Repeat
whether the rules, whether the rules and your promotional avenues are being narrowed down. What is the scope of interference in such like matters?
See, insofar as promotional opportunities are concerned, There have been some broad philosophical statements made by the Supreme Court starting from KGS, but in CSIR versus KGS, but Supreme Court said, a person is recruited for a career and not for a job. Therefore, there must be reasonable promotional opportunities. This was the philosophical statement made. But employers came out with a novel scheme, that is stagnation movements. Therefore, how small are the inadequacy of the promotional opportunities, the threshold at which the courts can interfere is very, very unclear. If we take, say, at the level of, at the top, that is at the general manager, chief general manager, and all that, every organization will have to follow a pyramidal structure. Therefore, naturally, the promotional opportunities there, if you go and complain that there are no promotional opportunities, courts may not interfere. But take the case of a lower level cadres, like second division clerk or first division assistant. There the general approach of the courts has been, a person should have at least 3 promotions in his career. Stagnation movement is there, apart from stagnation. Minimum 3 promotions is what is expected to meet the legitimate expectations of an employee in a career of 25 to 30 years. The interference of the court in directing redoing of the organization structure or redoing of the method of recruitment are very rare, and I personally have not seen any such case. They may persuade the employer during the course of hearing, saying that, look, they are all your employees. They have been working for you for the last 15 years, 20 years, without any promotion. Can you not find a way so that performance of your organization will improve? There the court's role is persuasive and not determinative. Determination is very difficult because ultimately administrator knows what are the problems he has and what solutions he envisages to meet those problems. Therefore, the promotional opportunities, only one case I remember, that is, I think, Madras Metropolitan, some water supply corporation or something, where it said, when it came to diploma engineers, diploma holders, that classification on the basis of educational qualification is valid, but that classification would become invalid if it reduces the chances of promotion to a mirage or just a teasing illusion. And that is one of the fundamentals of service law, is that chances of promotion is not a condition of service. If you get your chance, consideration for promotion in accordance with Article 16 is your condition of service. Therefore, for lack of promotional opportunity, it is difficult to persuade a constitutional court to pronounce. It is left to the wisdom of the employer.
Yes, sir. While we're talking, the last question we will be taking, then the between the mode of recruitment and sources of recruitment.
Yes. See, mode of recruitment is the method, that is, whether it is direct recruitment, whether it is promotion, whether it is deputation. These are the modes of recruitment. Sources of recruitment is where from you get the candidates for each of these modes. Source is the pool from which you get candidates. Pool is the source and method is the mode. There can be, that is why I said, now there can be internal candidates for direct recruitment. There can be external candidates for deputation. But for promotion, there can be no external candidate. It can be called as a lateral entry at a higher level, which the government of India is trying to have at the secretariat level, but without much success. Because whenever the secretary's posts have been advertised to be filled on contract basis for a period of 5 years, the response has not been as per the expectations.
Questions, and now, as they say, that 20 सवाल तो नहीं, 3-4 questions. Like you said, there are lack of opportunities. But from where do you make that lack of opportunities into opportunities so that you can earn into lakhs?
Lakhs is not a big sum now for the advocates. I think now campus recruitment of advocates also.
Talking in general.
Then it goes. The opportunities, whatever we may say, that you have to create opportunities and all that. Ultimately, it comes from the confidence that the litigating public develop in you. How do you infuse or generate such confidence in the minds of the litigating public? One is, first thing is visibility. Visibility, I'm not saying in TV or webinar. Visibility in your office and visibility in court. Punctuality. The client must know, or a would-be client or an intending client should know. If I go to Vikas' office between 4 p.m. to 6 p.m. or even 6 p.m. to 8 p.m. or it may be even between 7 a.m. to 9 a.m., he will definitely be available. That is the punctuality and visibility. Second thing is visibility in the court. Visibility in the court is, of course, when your matter is listed, you have to be visible. And you should also be audible. But even when your matter is not listed, you should be visible in the court because you will be learning a lot. And these days, the persons who intend to litigate or who are anticipating to litigate, they also go to court and study who is there always in the court, who is there who will stand up without demur when his case is called. This is the thing. Second, there is visibility and punctuality. Second aspect is develop enormous patience. Because when a client comes, we tend to talk more. We should not. We should talk more in the court. With the client, we should be a good listener. Hear all his problems. Hear him out. then ask him, yes, you have this grievance. Is there a basis for your grievance in law? What is the law? Law is the rule governing the issue, or if there is no rule, general principles governing the issue, and then you give your honest assessment as to how to improve his case, or whether his case is hopelessly bad, or with some creative exercise. Creative exercise means, don't laugh, it has two aspects. Creative exercise is creative thinking. Second is creating a cause of action. Because a good advocate is one who creates a cause of action where none appears. Because without a cause of action, you cannot go to court. Therefore, certain amount of creativity. Creative thinking is one aspect. And find ways to make out a modicum of cause of action. After having done this, then you start talking. Don't allow him. Why I am saying is, all this is, he is master of facts. He is the person who is agonized. He is the person who comes for a relief. You cannot try to get him a relief which he does not want. Or you cannot assure him a relief which law does not permit you. Therefore, hear him out fully. Even if you ultimately say that you have no case, while going out of your chambers, he must be satisfied that he really has no case. Because human mind assumes that always, yes, I have been wrong. If according to you and according to law and according to the rules, he has been wrong, assure him that you will be right. If in law you don't see a wrong, you tell him that you may be dissatisfied, but you cannot be an aggrieved person to go. In fact, in the initial stages of my career, I became more popular by denying the cases, giving this out very honest opinions. People were telling that when you go to Rajagopal, he refuses most of the cases. And they were threatening that you may lose the practice. But I never lost, because it is this honesty which built up my practice. There may be persons who have other ways to build up the practice. But this is the way I built up the practice. This is the way I created opportunities. I can only speak from my experience. Everybody will have his own way of creating opportunities. But these are the three essential things: visibility and punctuality, and thorough reading of the problem, and not giving unreasonable assurances to the litigant.
Like you were saying that you have to extra cases. So it is just, I am just reminded that if you give a stone to someone and who is a good sculptor, he will carve out the best things and they will bring the best things. So how do you chisel out the facts and law for the bench?
Voice is not very...
Sir, I am saying, just like a sculptor, you give a stone, he will chisel it out and make it a good sculpture and people appreciate it. Same way, once there are raw facts, how do you...
Break in audio because...
so there's some internet...
yeah, there is some internet issue, but I have understood your question. How do you...
Stone into a sculptor. Same way, how do you take the facts and make it into a good law and case?
For doing, that is your question, if I may rephrase it. How do you formulate a case on the basis of the facts given by the aggrieved? dovetailing the facts without telling a lie is the basis. For that, you should read the law, assimilate it, and then think what should be the focus in presentation, so that in law I make out a case that his grievance is justified. That is the basis of the making out a brief. After getting the facts from the aggrieved, you have to cipher out the legal grounds on which his grievance can be projected. That is entirely your reading. And I would advise young advocates that even if they have to take 2 or 3 days for this thought process, let them take. I have made it a habit. If anybody wants to come for even a consultation at this age and stage also, if possible, give the file to me 48 hours in advance. If not possible, and in matter of grave urgency, at least send the file to me in the morning. Allow me time till the evening. So that I am speaking of discussing a brief already prepared by an attorney. Because we have to understand the fact, we have to cipher out the law that could, and the legal provisions or the constitutional interpretations under which we can make an arguable case for the litigant. I don't say winnable case. I say arguable case. This is how we sculpt it into a presentable case. I don't say absolutely winning case, because between the date of your filing the case and the date on which it comes for hearing, so many changes might have taken place in interpretations. As I was telling you about research of that, KBN research of that. Once it was, employment exchange was thought to be correct. Then the exclusion of you cannot proceed on the basis of employment exchange without advertisement, that became the law.
Take from today's session only, what modes do you suggest to the people that they should, it's a into you, that is it a good library, good knowledge, or good presence? How do you say that a lawyer can make his presence felt?
His presence felt is there. Now what has happened is these days, though I would rate as the most essential requirement a good library, these days library is not a problem. Many online law journals are available. Only thing is, people like me cannot read online. I would still prefer to have a black and white library. Say my colleague Jayant or your junior colleague, they may feel that having books is a waste of space. They may feel that, yes, what is the problem? I'll search it out. In whatever way you do, whether you have a physical library or an electronic library, use the library. Don't abuse the library. Using the library, as I told in one of my earlier sessions, is reading the judgment. Abusing the library is reading the headline. Therefore, Knowledge is power. Therefore, reading gives you that power. In any discussion, after all, in any court discussion also, whether you are well read or not is not difficult to make out. But whether it is effective or not, it is another matter. If you are well read, you can be effective, is my belief. And beliefs are always, I believe it to be true. It may not be true. That is, knowledge and belief are two different things. Where anybody making an affidavit will know what is the difference between knowledge and belief.
Is not suffice, but you have to read. In the normal course, they say if keeping books was good.
There are any number of cases. One difficulty with the advocates is, which I also am not free from this. We read a book only when it is needed. And when the need would arise, when the case comes. But at least you must have read this much, that when the case comes, you should know which book to read. To that extent, at least you read, you whether case or no case. That's all I can say, because nobody can say that I have read every judgment. One lifetime is not sufficient. But at least we should have read this much, say, yes, this is the issue. For solution, I may perhaps refer to this. We need not have read it fully, but at least our knowledge should be sufficient to guide us to the correct book or resource or reference, whatever you call.
Say that it's not necessary you should know the law, but you should know how to find the law. So on that note,
yeah, that is correct. That is correct. You put it more crisp and to the point. Broad principles we should know, because we should not be searching a principle which we would never find. And this is something that we develop by practice. That is why I said, whether you have a case or not, you go and sit in the court. Because we will be getting experience from others' cases.
It is just on the parting note, we will say, they say that your father will never tell you how to shave your beard. It is only take your pen and make you teach. So you just have to absorb and absorb. That is the two mantras for the being a successful lawyer. That's what people tell us. And friends, before we part for the day today, it is and we are truly indebted to Mr. P.S. Rajagopal, the senior advocate, Recruitment and Associates, who have been learning from him. And not only that, the end mantras by him, we keep it, the takeaways, just like in the end. Picture to mere baki hai mere dost. So keep on watching Mr. P.S. Rajagopal on Beyond Law CLC, and we will continue with the series of service law, and his services will always be appreciated by the society, by one and all. Thank you, everyone. Stay safe. Stay